Hello, friends. Father Frank Pavone here, National Director of Priests for Life. Welcome to our program, and welcome to another episode in our series examining the arguments being brought before the Supreme Court in the Dobbs abortion case. This is one of the most important cases the court has heard since Roe versus Wade, and the array and the beauty and the persuasiveness of the pro-life arguments being brought to the court now is unprecedented. Today is no exception. We're going to look at a brief submitted by Heartbeat International, and we have with us the president of Heartbeat International, which is the largest affiliation network of pregnancy help centers in the world, Jor-El Godsey, a good friend and collaborator in this movement. He is here with us, and so is the legal counsel for Heartbeat International. Her name is Danielle White. She obtained her law degree at a place that is very familiar to me, Ave Maria School of Law, where I've been privileged also to visit and speak. She was a senior editor for a time of the Ave Maria Law Review. She's a member of the Christian Legal Society, an affiliated attorney with the Alliance Defending Freedom, and does so much great work for our movement. Jor-El and Danielle, welcome to the program.
Thank you so much, Father Frank, for having us. We are grateful to be able to participate with so many good briefs that have been submitted for such a time as this. We believe this is a great time to be able to make a great case for the reason why women simply do not need abortion. And one of the best is that we love is the fact that there are so many things available, which really comes across in the brief.
The brief is excellent. I really enjoyed reading it. And let me pose, to set the framework for this discussion, this point. A lot has changed since Roe v. Wade. When the court looks at whether to change a decision that was made in the past, reverse one of its precedents, this is one of the things that has to take into account. Not only the basic question is our decision consistent with the Constitution, but the question of, what has changed since. Now, it's been almost 50 years since Roe v. Wade. And in the first part of this brief, you outline a mini history of the pregnancy center movement, because that's one of the big things that has changed. Trace for us the argument you make and some of the details of how the existence of alternatives to abortion was at the time of Roe v. Wade, and then you look at, especially at the time of Planned Parenthood versus Casey, 1992, when the court reaffirmed Roe, and now unto today. The pregnancy center movement has grown so substantially. Tell us some of the details of that and why that constitutes an argument to the court now for reversing Roe.
Well, I think I can get us to Casey, and then Danielle's got the goods from Casey on. But we know in 1973, only about half the states in the U.S. were actually allowing abortions of any kind. And of course, Roe begins to unpacks that for the entire country. But even pre-Roe, in 1971, when Heartbeat began, there were already several hundred pregnancy help outreaches. Now, some of them were actual pregnancy centers. The very first pregnancy center was opened in 1968 in Toronto and was quickly adopted as a model in the U.S. But those were literally in the dozens by the time Heartbeat begins, and just in the barely in the hundreds by the time we get to Roe versus Wade. But as Roe unfolds, and it not only did, of course, it ignite abortion in our country, we know that from thousands in 1973, it grew to 1.6 million, at its peak in the very beginning of 1990s, right? So that's the arc of abortion. But what happens simultaneously is the growth of the pregnancy help movement. As the failure of the politics was obvious to the Christian community, the pro-life community, then they had to engage not just in the political and in the legal, but in the practical. And that's where we saw people energized to join this movement. And so what we saw literally in the 1980s was an explosion of pregnancy centers. They began to dot the land and fill out the landscape of the United States, so
Yes.
that it was actually in the mid 90s, just after Casey actually, that we finally had one more pregnancy center than there were abortion clinics. And one of the and that's where we see the growth of that practical grassroots care that was happening in every community across the country. I mean, even today, Planned Parenthood laments the fact that they're only in 11% of the counties in the U.S., while
Mm.
pregnancy centers occupy 50% of the counties in the U.S. So these are the things that Roe did not take into consideration. The fact that there was opportunities for women to find something besides abortion. You know, the Heartbeat International began as Alternatives to Abortion International. That was the very
Yes.
mission we were called to. And so it
Yes.
grows significantly throughout the 80s into the 90s when we get to Casey. And then there's some really dramatic things that happen in Casey and certainly after that.
Yeah, so of course the key question that the court will be looking at for the Dobbs case is whether stare decisis requires the court to follow Roe and Casey, regardless of whether they were rightly or wrongly decided. And so before we even get to the question of what should we do with Roe and Casey, I think the court is first going to want to answer the question of, do we have to follow Roe and Casey just because they're there? And so in order to answer that question about stare decisis and whether the court must follow its precedent, it's going to look at a couple of key factors. Two of those factors I think we address pretty well in the brief. The first being the reliance interest of the woman on abortion and on Roe and Casey. And does a woman rely on Roe and Casey in order to meaningfully participate in society? And then the second is changed circumstances. And as Jor-El alluded to, the pregnancy help movement has been growing since the time of Roe and continues to grow. I mean, we're growing all the time, and not just in size, but also in scope. And one of the most exciting things that we learned in our research for the brief was just how dramatically the pregnancy help movement has stepped up to offer medical services to the women. When Casey was decided, there were only 3 centers in the United States that offered ultrasound to women. Now that number is far, far greater than 3, more than 1,500 to my recollection, without looking back at the brief. But just that overwhelming growth in being able to offer women medical services is something that has changed so substantially that the court doesn't need to rely on its previous precedent, and it can entertain the possibility even of overturning.
Yeah. Danielle, let's break this down for people. We go back to Roe v. Wade. Wasn't the court saying there, I remember some of the wording there about, well, you know, the woman who would find herself pregnant unexpectedly, if she doesn't have the option of abortion, and she has to go through with that pregnancy and give birth to the child, oh, there can be such overwhelming psychological harm from that. She's in I mean, basically, Roe was painting a picture that, oh, well, she's in a terrible position. And so here we come to the rescue with, you know, legal abortion. This brief that does a tremendous job in showing, wait a minute, things have really changed since then. Some of which you've already just pointed out in terms of the growth and scope of services of the pregnancy centers. But then in Casey, let's look at this question of reliance. When we talk about the reliance interest, Casey was essentially saying, tell me if I'm expressing this right, that whether or not we made a mistake in Roe by legalizing abortion, the fact is that women and their ability to participate in society have become so dependent on the availability of abortion that we can't change it now, right? We can't change it now because
That's
they
right.
need it they've come to rely on it. Isn't that somewhat of a demeaning argument to say, oh, in order for women to participate in society, they need abortion? No, it's not because they're going to work hard, they're going to study hard, they're going to get a good education, they can compete in the workplace, they're women, they're just as strong as men. No, it's not because of all that. It's because they have the right now to kill their babies.
It is demeaning. And as a mom of 4, I find it especially demeaning. And furthermore, I wrote this brief having just given birth to my 4th baby. She was about 3 weeks old. And I wrote this brief literally with her up on my shoulder as I'm typing away. And it just really struck me that how can the court say that? How can they say that women need abortion in order to meaningfully participate in the economic and social life of the nation? That's
Right.
insane. And
It's insane.
so much has changed since 1992. You think about even just the advent of the internet, the common use of the internet, and how much that has changed life, not just for women, but for everybody, but especially for moms. I mean, for a mom to be able to dial into a meeting at work from home because she has a sick kid changes everything for her. And so to say that women rely on abortion to be able to participate in society and to be able to fulfill their hopes and dreams is just really out of touch with reality. And it's really time for the court to update their understanding of what women are capable of.
Let's dig into that a little bit. The workforce. So you point out in the brief that at the time of Roe v. Wade, about 47% of moms of minor age children were in the workforce. Now it's more like 71%. Women are able to work and raise children at the same time. Now you mentioned about the advent of the internet as one of the reasons for that. Online, connecting with work from home and so forth, and certainly that increased during the pandemic. But other things too. For example, laws prohibiting pregnancy discrimination, right, have developed since Roe v. Wade to an amazing extent. Paid family leave and child support. Laws and programs that enable all of that to take place. And then you also have the safe haven laws, where if somebody does go through with a pregnancy, gives birth, and is just incapable of handling that child, she can take that child to a safe place, designated place, fire station, police house, hospital, and no questions asked. Then the child will be received and taken care of. So, I mean, so much has changed, and so many other things. The stigma surrounding out of wedlock births. You bring up an interesting statistic in the brief on that too. At the time of Roe v. Wade, only 13% of the births in the United States were out of wedlock. At the time of Casey, it was 30%. Now it's 40%. So all these changes, the justices can look at this and say, okay, the basis for the way we decided in those 2 cases is no longer there. And that by itself can be a reason, can't it, for strongly arguing to reverse these decisions.
Yes, absolutely. That's exactly right.
What else is at issue here? We've got the growth of the pregnancy movement. We've got all these reasons why pregnancy and childbirth do not stop one's professional work or one's education. But you go into some other reasons too that that enable the court to say we don't have to stick with. Stare decisis doesn't have to mean at this point that we're sticking with Roe and Doe. You give several other relevant arguments. Could you walk us through those?
Well, I'm trying to remember which ones you're referring to.
Well, first of all, the legal developments. Let's go to that part of the brief here. The changes in. Well, first of all, the quality of the reasoning in the original decision. In other words, a right to abortion is neither in the Constitution nor is it in the history and traditions of our country. So in other words, if a decision was constitutionally wrong 50 years ago, it's still constitutionally wrong today.
Yeah, that's correct. Really, the Roe versus Wade decision is really devoid of any constitutional mooring. It's just unhinged from the Constitution. There's no basis for it. And even pro-abortion, pro-choice legal scholars agree that it's a poorly reasoned opinion. It doesn't find backing in any of the traditional sources. This nebulous right to privacy is really kind of made up whole cloth. And
Right.
so it was wrongly decided at the time, and it's ripe for review, and it's ready to be overturned. We're ready for the court to base its opinions on the actual Constitution and not something that has just been invented for expediency.
The other thing, besides being so constitutionally weak, Roe is medically weak. It was medically weak the day it was decided, but since then, the developments in medical knowledge, that makes a difference too, doesn't it?
Yes, absolutely. We've had ultrasounds have improved dramatically in what they're able to detect, not just what we're able to see in the womb, but also what we're able to do for babies who are born early, the things that we're able to treat to improve the quality of life and the infant's ability to survive outside the womb. All of that is developing, and it's constantly changing. And this case is really all about that viability line. When does the baby become able to live outside the womb? And the Roe court said that was somewhere in 32 weeks, and then the Casey court kind of backed it off a little bit and said, well, maybe viability is a little earlier. But how can viability be the legal standard when the actual age is constantly changing and constantly evolving? And I think that's something
Right.
that a 15-week ban is really pushing on.
Danielle, there's another concept that you mentioned in the brief, and I've seen it in a lot of other places too. The question of the workability of the standard that the court has set forth. What does this mean? In other words, it seems that the court has come to a conclusion over all these years. Oh, we have to allow abortion. But then every time one of these state laws is challenged, as Mississippi's law was and so many others, the judges in the lower courts and even the justices at the Supreme Court, if the case makes it back up to them, are sort of at a loss as to how to consistently apply what the court has said in the past. Because they've said things, but they haven't defined them. They've said things, but to one judge it means one thing, to one judge it means another. Tell us a little about this unworkability and how that can also lead them now, in this case, to make a significant change.
Yeah, it has a lot to do with how the court evaluates the laws, as you alluded to. So first, Roe comes down, and we learned that all abortion laws essentially are going to be subject to strict scrutiny. And as Justice Thomas has said, strict scrutiny is strict in theory, but fatal in fact, meaning that just about any law that's challenged and is subject to strict scrutiny is going to fail. So under Roe, it looks like just about any law is going to fail. Well, that didn't really work out so well because it didn't incorporate the state's interest in the health of the mother as well as the life of the unborn child. So fast forward, now we're at Casey. Now the court says, well, no, it's not strict scrutiny, but we're upholding Roe. Roe stays, but it's not strict scrutiny, it's an undue burden. And so then, that goes back to the lower courts for another couple of decades. And then we come across to Hellerstedt, and the court says, well, it's not the undue burden. It sort of is, but it's not. And it's an undue burden if there's a substantial fraction of women who will be foreclosed from abortion. So now we have a new standard. So now that goes back to the lower courts. What is a substantial fraction? We don't know.
Right.
And it seemed like Justice Roberts tried to bring us back to the undue burden standard in June Medical. But the reason we got to a place where we had to go back to the undue burden standard is because the undue burden standard is unworkable in the first place.
Yeah, it's a mess. It's the jurisprudence of the court on abortion is a mess. And meanwhile, Jor-El, I want to have you comment on this. One of the most beautiful parts of the brief that Heartbeat International And for those that are just joining us, we're talking with the president of Heartbeat International, Jor-El Godsey. This is the largest affiliated network of pregnancy centers in the world. And with the general counsel, Danielle White, they've submitted this brief to the Supreme Court in this Dobbs case. Jor-El, one of the most beautiful aspects of the brief is the one that talks about lived experience. You are inviting the court into the lives and the stories of some of the people that the pregnancy centers have helped. And that is just awesome. Tell us a little bit about that and how you hope that impacts the justices.
So if we had written a brief that had all of the experiences they had, we'd probably still be writing it and not have made the deadline, because we know of hundreds, thousands, tens of thousands, and we know that there are hundreds of thousands more, maybe even millions of women whose lived experience really defies what the court has been trying to propose about and uphold in Roe and in Casey, because there are real women who have done better than abortion. They have, and the ones that we've encountered most recently and directly are those who have overcome chemical abortion and gone on to have meaningful lives. And you know, one of them that we highlight actually is stepped into nursing herself. You know, having walked this path, is moving in that direction. We see woman after woman who's able to make the decision. And Father Frank, we know at our heart, you know, as people of faith as well as of law, we know that there's a God who is at work in their lives and who is ready and waiting to interact with them and intervene with them into their situation. And often what she needs most is simply someone to come alongside her and say, you can do this. You know, sometimes, yes, it can be the material services, it can be the medical services that she needs, it can be the medical knowledge and understanding that kind of unlocks for her this reality, but ultimately it's simply someone saying, I believe in you. And we as people are exceptionally resilient. You know, I was kind of marveling that the most recent, you know, rocket that went in space was called the Resilience. There's something about the human nature that we are as a people resilient. It's what has allowed us to survive with God in a variety of circumstances, in difficult and dark situations, in catastrophes and challenges, but also in a variety of scenarios. And this is what every woman is facing. You said it earlier, the court's position is actually very demeaning. It says, well, you really can't do this yourself, so we're going to provide this other aspect so that you can do that. But we have these three beautiful stories that we tell, and it was difficult to determine which ones to
I
tell.
bet.
But we're grateful for these kind of brave women who said, yes, you can use my name and tell my story, because they're just representatives of how strong women can be, even in the face of what seems like a challenging situation. But we know time after time that women can do better. Often their own network of support surrounds them and envelops them where they originally perceived them to be at odds. You know, I can't tell you how many times as an executive director of a pregnancy center, I've heard a young woman say, you know, my parents are going to be very unhappy. They're not going to walk with me on this journey. And when the parents do find out what's going on, sure, there's those tense moments in the beginning, but more often than not, they surround her and envelop her with the love and care that she needs. But it also is a reality that the government has provided many, many more options. You said that earlier, not just in the laws that they've created, but the programs that she can get the care she needs. She can get help in a variety of places through a variety of ways. It's just the problem that most women are not walking around with that knowledge at any given moment. But the pregnancy centers are. They are the ones that have resource books that have page after page of how can we help her? How can we help her find housing? How can we help her get job training? How can we help her get access to childcare or to get any kind of these programs that she needs, whether they are government programs that she can connect with, or that they're community programs or church outreaches. There's a myriad of those programs that are available to help her make that positive decision for life, to come around her and do what we know has already been deposited within her to do, as far as being the mom that she's been called to. And you were right. If there's a path forward that says, well, I can carry this child, but I really don't know that I can parent, there's a lot of other people that are willing to surround her with that care and compassion and receive that child into their own home. She can even make the choice to choose who parents her child. Like, these are all positive choices that, frankly, in 1973 were just not as robust or widespread maybe as they are now. And it's not just that the internet made a path for her as a woman, it also made a path for all these other things to happen, connecting with adoptive couples, connecting with the resources where that can empower her to do that. It's a variety of things that make it so much more possible and plausible and likely that she can have not just survive her pregnancy and parenting, she can thrive in that environment.
This is really wonderful, and the brief is fantastic. I want to thank you, Jor-El Godsey, president of Heartbeat, and Danielle White, general counsel. This is great work, and I've always said in my talks to pro-life activists and to pregnancy centers around the country, I said, look, all the different parts of the pro-life movement work together, and we all need one another. Working in the area of law, we got to battle against laws that would try to discriminate against or even shut down pregnancy centers. And on the other hand, the law can protect and even help fund pregnancy centers. But here we see sort of the vice versa. We see the very existence and growth of the pregnancy centers now, because of arguments like this being brought to the highest court in the land, actually helping to change public policy, and we hope and pray in a big way with this Dobbs decision. So thank you both for the leadership you give, the work you do, for the brief that you've helped us today to understand. And we look forward to continuing to partner with you as time goes on in this great movement.
Thank you, Father Frank. We appreciate you very much.
Thank you, Father.
Thanks. And thank you, brothers and sisters, for watching. Let me remind you that at the website, SupremeCourtVictory.com, you can learn a lot more about this case, and you can read not only this brief from Heartbeat International, but all the briefs that have been submitted by so many different pro-life groups. Go to SupremeCourtVictory.com. You'll also see there the prayer campaign for victory in this case, and we look forward to joining you on further episodes of our program. God bless you all.